Hello everyone, my name is Aarti and you're watching HW News. Gujarat independent MLA Jignesh Mevani, who was arrested by Assam Police, was granted bail yesterday. He got the bail at a court in Assam's Barpeta district. Mevani was arrested from Palanpur in Gujarat by a team of Assam Police officials in connection with a case registered against him for his tweets asking PM Modi to appeal for peace. That's quite ironic. People are getting cases against them for asking the leader of the country to appeal for peace. Well, he did receive the bail from the Kokrajhar court for that, but within a few hours of getting bail, he was rearrested by Assam Police. What was the charge? That Jignesh Mevani allegedly assaulted a female police officer. This case was filed in Barpeta district on a complaint by a woman police officer who accused him of assaulting her and outraging her modesty. The court yesterday granted him bail, but it did have some questions for the police in this particular case. And in fact, the court pulled up the state police, saying that they filed a false FIR and abused the process of the court and the law. Not only that, the court went a step further and warned the police against converting our hard-earned democracy into a police state. Now today in this video, we will talk about what the court said, and then we will also talk about CJI NV Ramana's statement on the action or inaction of the government in following law. You can also watch the entire video, which is 20 minutes long, on HW News YouTube channel, but all the same. Now, on April 20th, in a midnight action, a team of Assam police officers landed in Gujarat and arrested independent MLA Jignesh Mevani. The arrest was in connection of a case which was based on a complaint by a BJP functionary in Assam. On 25th of April, Mevani was granted bail in that case, but as I said, he was rearrested for allegedly assaulting a female Assam police officer. She, in her complaint, said that Mevani uttered slang words at her and he physically pushed her when she was escorting him in a government vehicle from Guwahati airport to Kokrajhar on April 21st. According to the FIR, two other police officers were present in the vehicle. Now let us see what the court has said about this. Sessions Judge Barpeta A. Chakraborty, while granting bail to Jignesh Mevani, noted that the instant case was manufactured for the purpose of keeping Mevani in detention for a longer period of time, abusing the process of the court and the law. Moreover, he also requested the Guwahati High Court to consider directing the Assam Police to reform itself by taking some measures like directing each and every police personnel engaged in law and order duty to wear body cameras, to install CCTV cameras in vehicles while arresting an accused or taking an accused to some place for the discovery of some articles and for such other reasons, and also to install CCTV cameras inside all the police stations. The court further noted that the versions of the policewoman in the instant case was not trustworthy, and rather it was an attempt to keep the accused in detention for a longer period of time. The court requested the Chief Justice of Guwahati High Court to consider whether the matter may be taken up as a public interest litigation to curb the ongoing police excesses in the state. He also observed, and I quote, "Otherwise, our state will become a police state, which the society can ill afford. Even opinions is growing in the world for providing next generation human rights to the people in the democratic countries, like right to recall an elected representative, right to destabilize an elected government, etc. Therefore, converting our hard-earned democracy into a police state is simply unthinkable, and if the Assam Police is thinking about the same is perverse thinking." The policewoman alleged in the FIR that while she was escorting Mevani from LGB Airport, Guwahati, to Kokrajhar in the government vehicle, Mevani uttered slang words against her. Allegedly, Mevani also pointed his fingers towards her and tried to frighten her and pushed her down into her seat with force. Now, the Barpeta Road Police registered the FIR under sections 294, 323, 353 and 354 of the IPC. The court said the alleged slang cannot be held as an obscene act and the moving police van cannot be considered a public place under section 294 of the IPC. The court then also said that pointing fingers at the police officer with intent to frighten her and pushing her down into her seat with force cannot be held to be using of criminal force by accused with intent to prevent the policewoman from discharging her duties as a public servant. Therefore, the court remarked that commission of the offence under section 353 of the IPC was also not established in this particular case. The court also said that no sane person will ever try to outrage the modesty of a lady police officer in presence of two male police officials, and therefore section 354 of the IPC also cannot be applied against Mevani. Regarding the offence under section 323 of the IPC, the court said even if Mevani had pushed down the first informant into her seat and thereby caused bodily pain to her, this is still a bailable offence. However, the most important part of it all, the court observed that contrary to the FIR, the victim policewoman deposed a very different story before the learned magistrate. The court said on Friday that her version did not add up to the details in the FIR. Now, what the court found arbitrary was police action of rearresting Jignesh Mevani soon after he was granted bail on the basis of a case that it found to be manufactured. The court observed that it seemed like the aim of the second case was to somehow prolong the detention of Jignesh Mevani and nothing else. This rather disregard of law by the executive was also raised by CJI Ramana in his speech today. CJI, while addressing the joint conference of the chief ministers of the states and chief justices of the high courts, said that the judiciary will not come in the way of governance if it is in accordance with the law. He then illustrated certain instances of misgovernance which trigger litigation and then burden the court. He also cited some examples, one of which was this. If police investigations are fair, if illegal arrest and custodial torture comes to an end, then no victim will have to approach the court. He further said that abiding by the law and the constitution is the key to good governance. However, this is often ignored, and opinions of legal departments are also not sought in the rush to implement executive decisions. The CJI also expressed concern at the government not complying with judicial directions, which lead to burst-in contempt petitions. Well, that's all for this video today. Do let us know what you think about this in the comment box below. For more news and updates, you can log on to www.hwnews.in.